Hi, my name is Dasha and I'm a student volunteer at the Habeas Corpus project.
Hi, my name is Sahmidu and I'm also a student volunteer at the Habeas Corpus project, and this will be our third video broadcast. The Habeas Corpus project is a pro bono legal charity challenging unlawful detention. If you would like to donate to us, please click the link below. So for our first item, we will be looking at the secretive nature of immigration detention centres. There are many challenges in gathering information regarding the internal workings within these centres. Earlier this year, UN Ambassador Rashna Manju was denied access to Yerswood IRC and implied that the government may have something to hide. Last week, the Independent was also obstructed by the government in the investigations into Yerswood. So Dasha, can you tell us more about what happened?
Well, it appears that the Home Office are working to prevent damaging information about human rights abuses reaching the public domain. The article concerns the Home Office refusing to disclose information portraying the incidences of sexual abuse in Yerswood. Last August, Chief Prisons Inspectorate Nick Hardwick stated Yerswood was a place of national concern, following a report into the experiences of women detained there. The report detailed that approximately half of all detainees at Yerswood felt unsafe. This new article has shown that despite allegations of sexual abuse at Yerswood, the Home Office has refused to disclose any information regarding sexual violence, continuing to turn a blind eye and silence such incidents. The justification for withholding such information is due to the fear that it may damage the commercial interests of people and private companies running Yerswood. It seems the Home Office is actually working to cover up the abuse towards detainees, in contrast to preventing this abuse from occurring. Another shocking article appeared on the Guardian website on Sunday, exposing the brutality of Australia's offshore detention camps housed on islands of Nauru and Manus. Paul Stevenson, psychologist and traumatologist, has said that in his 40 years of work, he has never seen more atrocity than that of the treatment of asylum seekers on these islands. Could you discuss further Stevenson's accounts of the detention camps?
Well, Stevenson has stated in The Guardian that the Australian government is deliberately inflicting upon people the worst trauma he has ever seen. Firstly, Stevenson emphasises how there is no peace for detainees held on Nauru and Manus Islands through his 200-page written account. Suicide attempts are extremely frequent, and there are some accounts of medical emergencies occurring 5 to 6 times a day. The distressing stories range from mothers attempting to kill themselves, detainees burning themselves alive, and the consumption of razors, amongst many other dangerous forms of self-harm. Stevenson says that this is what detention does to people. It turns them against themselves to use themselves as currency. All they have is their own body to negotiate with. Essentially, what this typifies is the brutal conditions within these offshore detainment camps that drive such distressing incidents of protests. Moreover, detainees' internet access is heavily monitored, and no cameras are allowed inside the centres. Stevenson labels this as a deliberate attempt by the Australian government to prevent the outside world from learning about the conditions of such detention camps. Furthermore, Stevenson claims that all participants within these offshore prisons are all emotionally scarred, regardless of whether they are jailed or jailer. For example, many guards who are deployed there only last for 1 or 2 weeks before leaving their position. This typifies the extent of these horrifying events of everyone involved within these camps. Australia's practice of immigration detention is notorious worldwide for the trauma it inflicts on those seeking safety, and hopefully Stevenson's article will highlight the atrocities sanctioned by the Australian government. In addition to these abuses inside detention centres, the UK has seen recent cuts in funding for the Ministry of Justice, resulting in the hiking of court fees. It seems that it will now be near impossible for current and future detainees to fund their access to justice. Can you expand on this further, Dasha?
According to The Guardian, the court fees for asylum and immigration tribunals are set to increase by 5 times due to the Ministry of Justice funding deficit. The proposed steep rise is likely to act as a deterrent to those seeking future asylum, as the cost of appeal is too high. To put it into figures, an application fee with a standard price of £80 can go up to as high as £490. According to the Ministry of Justice, it is no longer reasonable to expect the taxpayer to fund around 75% of the costs of immigration and asylum proceedings. However, setting these standards that are so hard to reach will mean that fewer and fewer people will be able to challenge often incorrect administrative decisions by the Home Office, says Jonathan Smithers, the president of the Law Society. According to him, it is fundamental to the rule of law that access to the courts and tribunals should not be determined by their ability to pay. The provision of justice should not be an accounting exercise. This is especially true for those who are extremely vulnerable and simply cannot afford to defend their own justice. The Liberal Democrat leader, Tim Farron, highlights the important point that currently a high proportion of decisions are overturned on appeal, highlighting the necessity that they are accessible to everyone, irrespective of monetary means. It also highlights the issue of ill decision-making initially in the Home Office, placing a large burden on the judiciary to correct them. The Habeas Corpus project is greatly concerned by the increase in court fees as we witness the demand for pro bono representation as people can't afford to pay. These fees will make it once more significantly harder for many to access justice. And we have news that detainees are barred from access to justice within detention centres themselves, as we have been told that our website has been blocked inside Harmondsworth Immigration Removal Centre, the Europe's largest. When our client searched our name online, he couldn't access our website, relying instead on people outside of detention to pass on our details. This follows the news last year that our site was blocked inside the Word. The Habeas Corpus project are incredibly concerned by such blatant attempts to bar access to justice for those detained.
Hello, my name is Nabiha.
My name is Audrey, and we're student volunteers at the Habeas Corpus project.
Today we'll be discussing the Hossain and Others case. This case tests the lawfulness of the detained asylum casework, a process established by the Detention Interim Instruction Policy, now referred to as the DII, and the Interim Process Map, both of which were introduced after the Detained Fast Track, will now be called DFT, had been suspended in July 2015. I'll provide some context of these relevant policies. The DFT was a fast-track process in which asylum seekers were detained whilst waiting for an outcome of their asylum decision. In 2015, Minister of State of Immigration, James Brokenshire, advised the government to suspend its operation. One of the main reasons behind the suspension was that it failed to identify vulnerable applicants, including but not limiting victims of torture or trafficking, to ensure that they would receive a fair hearing. The Home Office then published guidance entitled the DII after the suspension of the DFT. This was for cases in detention for those who have claimed asylum and for those entering cases who have claimed asylum into detention. It states that the suspension of the DFT does not mean that asylum seekers cannot be detained. Lastly, the process map was also introduced to provide additional guidance to caseworkers. The Home Office introduced a DAC process map and interim process map for cases that are processes whilst being detained. The process map states that particular care must be given to applicants who, due to their particular circumstances, may require either rescheduling of interviews, extensions of timescales for submission of representation, or in some cases, release from detention.
Thank you. I will now talk about the facts of the case a bit. So this was a test case with 4 representative claimants, and these claimants' experiences were used to demonstrate some of the shortcomings in the DII in protecting vulnerable detainees with pending asylum claims. The claimants contended their detention for purposes of examining and determining their claims in detention was unlawful. The first claimant is Hossain. He was detained after being found living in the UK unlawfully for 15 years. After being detained, he claimed asylum on account of his membership to the Bangladeshi National Party. He was recognized as a victim of torture. However, his detention was maintained under exceptional circumstances, namely high risk of absconding and poor immigration history. The second claimant, MNK, was a Pakistani national. He had been living in the UK unlawfully for 7 years before being detained. He again was a victim of torture who sought asylum on the basis of his political opinion and obtained a Rule 35 report while in detention, which was not accepted by the DAC team. The third claimant is O'Lear, who was living legally in the UK from 2005 until 2011 under a student visa. In 2011, she applied for an extension of her visa on the basis of marrying her partner, who was an EEA national. However, this extension was refused. To make matters worse, she was also a victim of a forced marriage imposed by her parents. Subsequently, she applied for asylum based on fears of being killed by her family upon returning to Mauritius, and her asylum claim again was refused. However, the process was drawn out over several months because the country information guidance on Mauritius was outdated, and gathering evidence for her asylum claim proved very complicated. The last claimant is TCV, a Vietnamese national who arrived in the UK in 2014 as an unaccompanied minor. He was detained upon arrival, but eventually was given a Rule 34 assessment, and the Home Office subsequently released him as he was recognized as a victim of human trafficking. These claims challenge the lawfulness of the DII policy, as only in the last case the detainee was released from detention based on the independent evidence he had obtained while in detention.
Thank you. I will now outline the claimants' arguments. The main argument for the claimants was that the DII is a process equivalent to the DFT, which had been ruled unlawful in 2015 as per the JM case. The Home Department case, and as a result, the introduction of the DII did not change the process for detained asylum seekers. In particular, the DII was unfair towards complex cases, torture and trafficking victims, and those vulnerable because of their mental or physical illnesses, gender and sexuality. The DII was deemed unfair for the following reasons. Firstly, persons were held without prior screening. Secondly, it denied release even after independent evidence of torture or a referral to the National Removal Command in trafficking cases. And lastly, it failed to account time taken to obtain documents, reports or translations in more complex cases. Lastly, they also argue that the Secretary of State failed to duly comply with Section 149 of the Equality Act 2010.
In response, the defendants claimed that in most cases accepted by the DAC team, asylum claims were made by people already in detention and thus could not be screened prior to detention. Additionally, screening interviews were conducted in detention and included specific questions to identify vulnerable detainees. As well as this, post-screening interviews were held to review vulnerability issues. Additionally, caseworkers were made aware of the need to be flexible, and in March 2016, of 36 applications for flexibility, in 35 cases this flexibility was granted. Lastly, as the DII is a reversion of existing policy contained in the enforcement instructions and guidance, the public sector equality duty does not apply to it.
I will now analyse the court's findings. It was held that TCV, the Vietnamese minor, was unlawfully detained. However, all three others were held to be lawfully detained for purposes of removal from the UK. These three claimants were also held to be able to advance their cases for asylum and were all treated fairly. However, the Secretary of the State did not meet her public sector equality duty in considering claims of asylum in detention, as she had not paid due regard in all aspects to her public sector equality duty when considering asylum claims in detention. However, this non-compliance with the equality provision did not render the decision unlawful. As a result, the outcome of the case tells us that the DII is a lawful process and will continue in its operation in cases of detention.
The Habeas Corpus project feels disappointed by the outcome of this case because it validates the Home Office's position in continuing to detain individuals for administrative convenience who are applying for asylum, and it creates further ambiguity in relation to unlawful detention. However, Habeas Corpus project will continue to provide access to justice for vulnerable detainees and to challenge unlawful detention.
Thank you.
Thank you.